Hey, Joe Zarzaur here with Dr. Evan Malone. People sometimes hear the phrase wrongful death and they think, okay, what does that mean? That simply means somebody was involved in a traumatic event that was the result of somebody else's carelessness, and the person not only was hurt, but they were killed. Wrongful death is a creature of statute, which means it was a law. There are laws that are passed in each state that give the right of a person that is deceased to actually bring a case. What we're going to talk about today with Dr. Malone is Florida law in regards to autopsies, when they're required and when they're not. The only reason that gets brought up in our practice is in the context of a wrongful death case, which is, again, a personal injury case when the damages are the person has passed away. So, Dr. Malone, what is the law in Florida in regards to autopsies when they are mandated by law and therefore must be done by the medical examiner, and when they're not?
Okay, so you just said my first part of the answer, medical examiner. So the state of Florida operates on a medical examiner system. So there are, I believe, 24 jurisdictions in the state. We are District 1, and it's our 4-county area extending all the way over to Okaloosa, or actually Walton as well. So Walton, Okaloosa, Santa Rosa, and Escambia. So any death that's reported to the medical examiner's office that needs to be investigated is listed and adhered to by Florida statutes. And then the investigation may include an autopsy. It may include just obtaining a history, and that's it. So that is up to the discretion of the medical examiner. And we'll share that list in the link below, but I'll read you just a couple of them of the examples of things that are investigated and reported to the medical examiner. Would be any death by accident, homicide, suicide, death while in police custody or with law enforcement, by poisoning, by any injury that it just doesn't make sense. Okay, and then unattended death, meaning someone is found in the home, they weren't under anyone's medical care, family found a deceased person. Okay, so that gets called in. And then your question was, what is required for autopsy in the state of Florida? So
what is required, or when is it required?
When it is required. So the easiest, shortest list is a child under the age of 1 where they suspect SIDS, sudden infant death syndrome. Okay, that is a must. Autopsy must be performed. That is not something that would just have just a phone call and investigation. Okay, yeah, we're good. We're going to release the body. So that is a full autopsy. The other full autopsy, mandates are. And I'm going to read it directly right here. A reasonable suspicion exists that a death might be by criminal violence or by any violence sustained in prison, penal institution, or police custody. A reasonable suspicion exists that the death is by accident, suicide, poison, unless, and then there's certain, caveats there, meaning unless it is very evident that there's a gunshot wound to the head, and in that instance, perhaps they'd say we don't need to do an autopsy here. And then the death of a child that is otherwise in good health is always got an autopsy. So over the age of 1, if it's a 5-year-old child who dies and they were in good health otherwise. And then lastly, any unusual or suspicious anything that's reported to the medical examiner, unless they have a really good reason not to do it, they would be doing an autopsy as part of their investigation as a whole.
So basically, the statutes and this administrative code that we'll put links to in this video give a lot of discretion to the medical examiner in Florida as far as when they need to do an autopsy, and if they do an autopsy, how extensive it should be, and whether or not it's one that's required or not by statute is also pretty much left up to the discretion of the medical examiner. So the reason this comes up in our practice is that we are trying, in our practice, obviously, to address the family's needs as far as connecting the death to the negligent or reckless or careless conduct. And for us to do that, the death has to be occasioned by or caused by the carelessness or recklessness of the other party. And if you have trouble doing that, you have trouble bringing a wrongful death case. So this hopefully answers the question, along with the links we're going to put referencing the statute and the administrative code, about when an autopsy in Florida is required and when it's left up, when the actual decision to do an autopsy is left up to the medical examiner, who may just choose to listen to the facts, right, from the investigator and choose not to do an autopsy. So if you have questions about wrongful death cases, autopsies, you can find us on the web at zarzaurlaw.com, or you can call us at 855-HIRE-JOE. Thank you.